Ladies and gentlemen, my name is David Solomons from Cubism Law. I'm now going to talk to you about shareholders agreements. My wife has told me that when I talk about shareholders agreements, I must look down at the camera and not look up at it because my eyes look like slits. I don't really know where to go with that, so let's get on to the shareholders agreement point, shall we? Okay, what is a shareholders agreement? Well, in simple terms, it's an agreement entered into by the members or shareholders of a company that regularizes the corporate relationship between them. Do you have to have such an agreement? Well, the truth is that many companies exist and exist well without such documents. Because in fact there is already a document that regularizes the relationships between parties, and that is the corporate constitution, which is the Articles of Association. The problem with this document is it's a fairly standardized document. It's very formal, and it doesn't really get into the nitty-gritty of the relationships between the parties and what they should be doing or not doing, and what they're allowed to do, and what their obligations are both to each other and to the company. So what kind of shareholders agreement would one have if one had decided to create such a document? Well, like many legal questions, there are a number of answers. I suppose the real answer is it depends what kind of company you've got. Let's imagine for a moment the company that 2 or 3 parties formed was a simple company formed purely for the purposes of carrying out a single objective, shall we say the purchase and development and then sale of a single commercial property. In those circumstances, the document will be reasonably simple. It would deal with the rights and obligations of each party. There wouldn't be too much about how a party might sell its shares to the other or purchase another's shares, because the intention is that it's only a short-term document, and therefore the parties should be, fingers crossed, in and out of this corporate relationship in a short while. However, I think it's fair to say that most companies are formed with the intention of a middle to long-term relationship between the parties as shareholders, and therefore, if you like, the company is the bones of the relationship, and the shareholders agreement puts the flesh upon it. It lays out all the terms and obligations that the parties might wish to ensure that each other are bound by. Now, why do we need to have such a document? Well, the best answer perhaps is it's human nature not to have things written down in certainty. What do I mean by that? Well, let's imagine that 5 people were sitting in a room and they all agreed to do something together. You could be quite sure that all 5 parties had a slightly different idea of how that would be done, what the benefits were for each party, and how they would deal with it if it went wrong. If you were to simply leave it in the minds of the parties, there would be no way of knowing whether everyone agreed with each other or they were on entirely different tracks. Therefore, if it's inculcated into a shareholders agreement, it means that everyone knows what they're supposed to do and what they're not supposed to do. So what might some of these obligations be? Well, for example, it would be quite normal to have in a shareholders agreement details about whether the shareholders can appoint directors, and if there was an equal directors vote on the board of directors, how that would be resolved. Whether every party had to invest their entire time in looking after the interests of the companies. This may not be appropriate because some parties may have other corporate interests, and this must be discussed and considered. If the company makes profit, what will happen to the dividends? Some parties may wish all of the dividends to be distributed because they need the cash. Others, for example, wish to invest more in the future of the company by capital machinery. Once these things are in a shareholders agreement, they lay out exactly what was intended by the parties. Perhaps even the most important thing is the conversations that take place before the shareholders' agreement is drafted by the lawyers. It's those conversations that give meat to the whole transaction. And then, of course, we come to the difficult questions. If one or other party wishes to sell its shares, and there are many ways of dealing with this. And this deals with the offer by one party to buy another's shares, or how the valuation of the shares will take place, what would be fair in the particular industry in which the company is involved in. And then occasionally you have fancy clauses in agreements that are known, for example, as Russian roulette clauses, or I think the South Africans call them Texas shoot up and hold 'em clauses. These are clauses that basically say if the parties cannot agree, then one must buy the other out immediately. And also, when one is drafting a shareholders agreement, one has to ask an important question. Who am I trying to protect, and why? In many circumstances, you will have a company whereby there is a majority shareholder, i.e. a shareholder who has more than 50% of the shares, and minority shareholders. And we create clauses in agreements that protect minority shareholders so that their position is not abused by the majority shareholder. And there are variations on this where the majority shareholder is the major investor and indeed holds the power of the company, and clauses will allow certain decisions that would normally be made by all of the shareholders only to be made by the majority shareholder. This all depends on negotiation and discussion of what the parties intend. So you can see there are many types of shareholders agreements and many things to consider. The very best type of shareholders agreement is the one that everybody works hard on, and then it's signed and it's put away in a dusty deed safe somewhere in the bowels of a firm of solicitors' office and is never brought up again. What that would mean is that the corporate relationship and the company itself was a success, because they never needed to look at what was written in the first place. If it were only so. Thank you.